Would you let the attorneys into the courtroom?
Yes, please.
And letting you in the courtroom and recording. Asking the attorneys to start their videos. I can know we can start. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-7063, Joseph V. Fisher, Appellant, versus Pension Benefit Guaranty Corporation. Ms. Gaffney for the appellant, Mr. Cooper for the appellate.
Good morning, counsel.
Good morning.
Counsel may proceed.
Thank you, Your Honors. May it please the Court, Allison Gaffney on behalf of Appellant Joseph Fisher. There are several issues raised in this appeal, but I'd like to spend my time this morning focusing on one of them. And that is the question of whether the Appeals Board's 2016 decision was new agency action or a more complete explanation of its 2011 decision. This Court's answer to that question could resolve this entire appeal. If this Court determines that the 2016 decision was not new agency action, then it need not reach what otherwise is a predicate question of whether the matter should have been remanded in the first place. And it need not reach the arguments regarding the regulation that the Appeals Board relied upon for the first time in 2016, CBGC Regulation 4044.4b. As the Supreme Court explained last year in Regent, an agency on remand may do one of two things. It may provide a fuller explanation of the reasons given as part of its initial action, or it may start afresh and take new agency action. If it does the former, it may elaborate on the reasons that it gave as part of those initial actions, or as this circuit's precedent has described it, it may provide an amplified articulation of those reasons, but it may not provide new ones. On the other hand, if it takes new agency action, it is not limited to its prior reasons, but it must comply with the procedural requirements for new agency action. And here, there's no dispute.
The second decision on its face says that this, i.e. the second decision, is final agency action.
That's correct. It is final agency action, but it is not new agency action. It also says on its face,
it has to be new agency action because the district court set aside the first decision.
The district court did reason that the word set aside would make it new agency action, but that is incredibly overbroad. The word set aside comes from the APA itself, of course.
And is the standard APA remedy, right? The only way the district court could not have set aside that decision is if it had done the very unusual course of remanding without vacating, and we have a very specific test for when courts are allowed to do that, and there's not a word of any of that in the district court's first opinion.
But if the word set aside, as you said, that's the standard remedy under the APA, and so if those were the marker of new agency action, that would mean that for nearly every instance of remand governed by the APA, there would be no need for the prohibition on post hoc rationalization. So it would completely do away with that foundational principle of administrative law.
Which is not hugely concerning if you think that another foundational principle of administrative law is the Chenery Doctrine, and this is exactly what happened in Chenery, where the agency gave one rationale, the court set it aside. The agency gave a different rationale on remand, and that second decision was fine.
The second decision was fine because it was new agency action, and that was the holding of Chenery 2, is that the agency is not limited to one procedural. The agency has different procedural options on remand. It may take new agency action, but if it does so, it must follow the procedural requirements for new agency action, and that's what the Supreme Court said in Regent.
Is there anything in APA procedural law that would prevent if the agency, if everything was fully briefed and argued the first time around, when the case comes back on remand from just deciding it?
The Supreme Court addressed this question in Regents. It said that the procedural requirements here are not just idle formalities.
Sure, and that's clearly right if the court sets aside a rule or a policy or something of that nature, but this just seems completely unexceptional. I mean, it happens in courts all the time. You brief multiple grounds, and it's not a legal requirement to rebrief when things come back on a remand.
No, it is not a legal requirement to rebrief, but it is also a legal requirement that the agency may not provide new rationalizations for the first time on remand. The procedural requirements are the marker of new agency action. And those procedural requirements will vary depending on the agency action at issue. It may be that the procedural requirements are more extensive in formal rulemaking or formal adjudication. Here, we have informal adjudication and the procedural requirements are not as extensive. But in Regents, they were even less so. The agency action at issue was DHS announcing the policy change. But nonetheless, the Supreme Court said the procedural requirements matter here. They serve important values of administrative law. And it cannot be that simply considering a new rationale for the first time on remand would make it a new decision in and of itself. The agency must follow the procedural requirements.
Well, our cases seem to focus on either what the district court said, and B, what the agency said on remand. So we don't have a case here where the agency said we're sticking with our original point of view, but we want to make this additional observation. Nor do we have a situation here where your client wasn't fully advised of what issues were to be raised on remand from the district court's point of view. So I'm wondering, as to procedural requirements, what you have in mind. My question is, you had full notice because the district court elaborated in its first decision why it was remanding.
One point first is that the agency on remand did say precisely that it was that the 2016 decision was a revised and more complete explanation of its 2011 decision. So
and if you stick with that, then the agency would not have been conforming its action to the district court's remand order.
The agency had the choice on remand. It described its action as a more complete explanation, but then it went into an impermissible post hoc rationalization.
Well, what I'm trying to draw the distinction between is the district court said not only is the policy ground a problematic, but there were other issues that the agency simply never addressed and that could be dispositive.
The district court said that the agency had not addressed whether the policy that it relied upon could apply to Mr. Fisher's factual situation. But it was clear on its face that the policy did not apply to the factual situation where the request was denied, not only submitted but also denied before the notice of intent to terminate was submitted. I see that I'm running into my time.
So what about the regulation?
What about the regulation?
Said it also wanted the agency to address the regulation, and in the first decision, the agency has not done so.
Correct, and that is exactly what makes its decision to address it on remand an impermissible post hoc rationalization.
Well, I guess I don't understand how you see the APA functioning then in this type of situation where a district court expressly says, I need the agency to address two matters. One, it addressed in part but not sufficiently. And the second, it didn't address at all. And so I'm setting aside the agency's first decision.
This runs up against.
And, excuse me, go ahead.
Oh, sorry. The court can only affirm the agency action on the grounds invoked by the agency at the time of its decision, and it cannot substitute its judgment for that of the agency. The agency did not consider this regulation relevant to its denial of Mr. Fisher's request. Whether or not the court did, the court cannot substitute its judgment for the agency.
Any further questions?
No questions.
All right, thank you. Let us hear from counsel for Appellee.
Good morning, Your Honors. May it please the Court. Kenneth Cooper on behalf of the Pension Benefit Guaranty Corporation. I would like just to emphasize a few points that were just discussed. One is the point that the PBGC Appeals Board really had no choice but to make a new decision based on what the district court instructed to do.
The question, though, is if they're going to make a new decision, shouldn't they have followed, or should they have followed the normal procedures with reference to a briefing, hearing, whatever you would normally do with a new proceeding?
Well, everything was already before the court in the 2010 appeal. There was no need to start with a new proceeding. The district court had told the appeals board exactly what to address. Those issues had been addressed by Mr. Fisher in his original brief in 2010, so there was no need to start from the beginning with a new procedure.
Does that make it then a post hoc rationalization on the first proceeding if you don't do anything else, rather even though you called it a new proceeding? Is it just a post hoc rationalization?
It is not a post hoc rationalization because it was a new decision. The arguments, as I said, were already before the board.
That would normally be the case in a post hoc rationalization, would it not?
Well, you wouldn't it wouldn't normally do that if the issues were already in place. If I could compare it to Regents, in Regents there was a memo by the DHS that just said very briefly, this is illegal. The district judge remanded it simply to give an opportunity to the DHS to offer some new explanation. And so the Supreme Court found that they did have to start over because they had to come up with new reasons. Here also, there was no predetermined conclusion. The board had to adjudicate this. In Regents, the DHS could have decided not to go further and just leave the DACA in place. But here the appeals board had to make an adjudication. The result was not predetermined. In the district court's remand, the judge specifically said if the board denies the appeal on remand, then Mr. Fisher can challenge that decision. So really all these issues were before the board. It was not something that came up simply in the second decision.
So your position simply is not to contest appellant's argument about the proper procedures have to be followed, but rather that the record here shows that the issues had already been fully briefed, and appellant showed or has shown nothing to indicate that he did not have a full opportunity to get his views before the agency on remand?
Yeah, that would be correct. I wouldn't say as a generalization that they would have had to make a new decision, but saw it as an exception. I'm sorry, put in place new procedures, and then the board saw this as an exception. I think they just saw it as the decision. The issues were briefed, as you said. The district court told it what to address. It couldn't just start pulling in issues that perhaps Mr. Fisher wouldn't have had a chance to brief before.
Well, that's sort of the point of my question. In other words, hypothetically, had Mr. Fisher himself not raised the regulation and it had come up only before the district court, then do you agree that there would have been some procedure on remand to give him an opportunity to get his views before the agency?
So the question is, if he had not raised it at all in his appeal? Yeah, well, I think the district court would have likely said something different in that case. I'm not sure how it would have come up had it not been in the appeal.
This is a hypothetical, just trying to understand how far the board's position is going on procedures. I'm just following up on Judge Sentelle's question.
I think if the district court, if a district court sends it back and says this decision is deficient, I want a new one, then I think you would likely need to start a new procedure.
Anything further?
No, if you have no other questions, I don't have anything further.
All right, counsel. Colleagues, any further questions?
No further questions.
All right, thank you, counsel. Counsel for appellant?
Thank you. Quickly, the district court in its remand order has asked that the appeals board address three things. Two of those were closely tied to the rationale explained by the appeals board in 2011. And one of those is the regulation. So the district court, in terms of providing an amplified articulation that would have not been an impermissible post hoc rationalization, the appeals board could have chosen to amplify those reasons that it gave previously, but it did not. That was a choice that the agency had, regardless of what the district court told it to do. The Supreme Court in Regents rejected the argument that simply because the agency was invited to do something by the district court, that would make it permissible. And in Regents, there were multiple reasons in the first memo, and the court said that the reasons that were given in the first memo and then amplified in the second memo, it went ahead and evaluated those under the arbitrary and capricious standard as governed by the APA. So it was only the reasons that were not raised in the first memo that were impermissible post hoc rationalization. And the same thing would apply here. It's just that in the 2016 decision, the appeals board focused entirely on this new rationale. And it really isn't an issue of whether Mr. Fisher raised the issue. It's not a question of notice. It's a question of what the agency rationale was for its decision. That's the only grounds on which the reviewing court may judge the agency's action.
All right, anything further?
No, thank you very much for listening to my argument this morning.
All right, thank you. We will take the case under advisement. All right, good morning, counsel. Counsel for Appellant, you may proceed.
Case number 19-7121, Darioush Radmanesh, Appellant versus Islamic Republic of Iran and Iranian Islamic Revolutionary Guard Corps. Mr. Yanov for the appellant, Ms. Al-Kadi, appointed amicus curiae.
May it please the court. My name is Mike Yanov, and I represent the appellant, Darioush Radmanesh. This case is about protecting an American from Iran's brutal treatment of anyone it disagrees with or wants to intimidate. The very purpose of Section 1605A, the terrorism exception to immunity in the FSIA, is to provide Americans abroad protections and make sure they are treated outside of America under well-established bounds of international law. It creates a cause of action for that very purpose. The court takes the alleged facts as true given Iran's failure to appear and a default judgment proceeding. These facts include Radmanesh and his family from the outset of Khomeini's takeover in 1979 being held as prisoners in their own home and being told that they were not
Has he been held hostage within the terms of the statute?
He has been held hostage, Your Honor. Admittedly, that's a closer call than torture, but he has been held hostage. His family was held hostage during that time period.
Well, never mind his family. Now, he's the plaintiff here, right?
Yes, Your Honor.
Okay. Now, when is he held hostage?
He was, well, if we're moving past the family, when he was conscripted into the military, and we're not making the argument
Being conscripted into the military is not being held hostage, is it?
It's not. We're not making that argument.
Okay, let's leave that subject behind us then. When has he been held hostage?
Yeah, you're held hostage, Your Honor, when you are, one, not allowed to leave, you're detained.
What does the statute say being held hostage means?
It's detained with a threat to kill or continue to detain and compelling that person to do or refrain from doing an explicit or implicit condition for release of the hostage.
Okay, now what was the time here when he was held hostage in that sense? Is to say he's under their within their custody and control, and they're doing it to extract the performance of some other act by him or some other person.
Yeah, so the kill or be killed order is by itself both torture and hostage taking. It is requiring him to commit an act in order to not just escape, but in order to live.
Forget about the torture claim on that kill or be killed. They did not say, if you kill him, we're going to turn you loose, did they?
They did not.
They didn't make the killing of the Iraqi a condition of his freedom, assuming they're holding him at that point. They didn't make the killing of the Iraqi condition of his freedom, did they?
That's true. In fact, they made...
So then is it hostage taking within the meaning of the statute?
it is, but because what they did was they came up even short of releasing. Kill or be killed is, we're not even telling you we're going to release you as a result of this, but you will die because we're holding you at gunpoint if you don't commit what is effectively a war crime. Killing somebody in their sleep who's not engaged is a war crime under the Geneva Convention. And so it's even short of we will release you. It's you don't survive this moment unless you commit this war crime.
It's actually not a war crime to kill members of hostile forces in an armed conflict when they're not actively fighting. You have to accept a surrender, but you can kill members of hostile forces when they're sleeping. That's a horrible thing, but that's a lawful act under the laws of war.
Yeah, and that's the only reason I say arguably. It is an outrageous act, and the outrageous act.
It's not arguable under the laws of war.
Fair enough, Judge Katsas. Fair enough. Fair enough. But to place Radmanesh in that position at gunpoint is far beyond. It's most akin, if I'm to compare it to something, to Russian roulette.
That may be, but nonetheless, it's not something where he's being held in custody amounting to the hostage taking on a condition that he perform an act. And you keep saying, well, he's going to be killed. That takes it out of the range of hostage taking, doesn't it? Because hostage taking involves holding somebody conditional to the performance of an act by themselves or a third person, or non-performance.
Your point is a fair point, and
he shot and killed him. He didn't get. If he was in custody, then, which of course is, that's not actually necessarily the case. But if he were, he wasn't released when he killed him, right?
True, he was not released as a result.
So doesn't that prove that this is not hostage taking?
Well, admittedly, the hostage taking is a much closer call than torture is, because there's certainly not an explicit condition of release tied to it. What we're arguing is that it's an implicit. If you don't do this, you're not going to be released. And then backing up to his family, I do believe that's relevant, because you can be prisoners in your own home. They were, and you can be hostages in your own home, even though it is from his dad, not him directly. So I think all of those in totality are hostage taking, but admittedly, that's a much closer call than torture. Torture is not a close call, because you need an act by a government official. That's undisputed here. Certainly after he was conscripted, that's undisputed. Who suffers severe mental or physical pain or suffering. And third, it's intentionally inflicted, meaning it's not just a broad order in the context of military. It's not just a broad order. This court said in Price that is a non-exhaustive list as to the intent element. The first element's undisputed. Amicus in the district court kind of glossed over the third element, the intent element, particularly in the kill or be killed order. The kill or be killed order alone establishes intent. This was not a broad order to his entire troop or to the Iranian military in general to go do these things. He was pulled aside, told he was going to be an American martyr in this mission, and then he was told at gunpoint, go kill this sleeping Iraqi soldier. That is intent. He was singled out, and he was told to do this on his own.
Torture?
It is
a terrible
torture.
thing, but is it torture within the meaning of the statute?
It is torture, Your Honor. It's torture because it fits within what this court says is universal condemnation. War crime aside, it is universally condemned to force a soldier at gunpoint to go kill somebody else.
Suppose you have a group of soldiers in the field and they come across a uniformed member of the enemy who's sleeping, and the commander says to one of the people in the group, go kill that enemy soldier. Is that anything other than what just unfortunately happens in war as a matter of course?
Not necessarily. It wouldn't necessarily satisfy the intent element or the severity element, because it's simply an order. There's no punishment associated with it. You're not told at gunpoint. It's not a kill or be killed.
In the middle of combat, if a soldier disobeys a lawful order, lots of very harsh things can happen to him. So the making the or be killed part of this explicit doesn't seem like a big step from normal wartime horrors.
Well, it certainly does if you refuse to obey the order, because if you believe the order to be true, then you will die as a result. That there are consequences is a fact of fighting in the military and a fact of being at war, no doubt. But to hold a gun to somebody and say, go kill him, is implicitly, if not expressly saying, kill or you will be killed. It is worse than a form of Russian roulette, which is torture.
The statutory term of mental pain, suffering, refers to prolonged, I'm having a little trouble focusing, harm caused by or resulting from. What's the prolonged harm that makes this fit within the torture definition in the statute?
Well, it's prolonged harm resulting, not prolonged torture. So the totality of the torture or the length of time that he is tortured is not what the prolonged focuses on. It's the prolonged harm resulting. That's a damages element.
If we use it as broadly as you seem to be, then torture becomes anything that has happened to him that might be bothering him for a long time. Can that possibly be what that statute means?
It's definitely not what it means. It says this court defined it in Price as an act of universal condemnation. And a kill or be killed
that's a different
order
element.
is an act of universal.
That's a different element. They were looking at subsection B, or I'm asking about subsection B. What's the prolonged harm here that fits it within the mental element?
Well, the harm is to put anyone in the position of murder or be murdered, kill or be killed. Is a psychological gain that is far beyond any bounds of appropriateness. It wouldn't be appropriate if the American military did it, Iranian military, any military in this world, to hold one of your soldiers at gunpoint and say kill or be killed.
So you have thrown out the phrase universally condemned. And is that with reference to the kill or be killed order?
Yes.
And what do you cite as authority that this is universally condemned?
I don't have something this outrageous. What I have are the Scipio cases and the Mihanovic cases, which we've cited, one out of the District Court in D.C. and the other out of U.S. District Court in Northern District of Georgia, which cite requiring someone to play Russian roulette as included within the acts that
Okay, so you have two district court cases and that's it?
Yes, I don't have a case talking about kill or be killed orders.
Well, I thought you might have a citation to an international convention, et cetera, in response to the points that Judge Katsas's questions were making. Don't you have to overcome that in order for your client to fall within the statutory definition?
I don't think so, because Russian roulette is not near as severe as kill or be killed. Russian roulette only impacts the individual.
According to what? 2 district court judges. I'm just trying to understand this. I mean, they may be correct, but I'm just saying that's all the authority you have.
It is.
And the international conventions and the law of war have not gone that far. At least explicitly.
Yeah, I don't have cases saying that a kill or be killed order is not that either. I don't have either one.
Well, that's what I'm trying to understand. What do you need to show? And we have a series of cases, including an understanding of why these provisions are construed narrowly.
Yeah.
It seems to me that means that you have to come forth with something. And with all due respect, judges may disagree on whether there is a statutory violation, as our cases indicate, where we reverse the district court judge.
That's true, Your Honor, and that's why it's a de novo review. It's not abuse of discretion. It's a de novo review on the law and on whether it's severe enough, and that's what this court ultimately has to determine.
Well,
I don't have a kill or be
severe
killed
enough.
case.
Is there harm enough in this case? Do they come within the statutory terms on that? If you do not succeed on the kill or be killed incident, is there anything else here that comes within the statute's definitions of torture?
Well, I think the totality of the family treatment and everything else, if the single act of kill or be killed...
The family treatment, don't you have to have something about how where he is tortured to come within the statute?
Well, that's true. That's true, but...
This is not a place action.
That's true, but he's in the household, so it's true, Your Honor.
What else do you have that would indicate an incident or incidents in which this plaintiff is tortured?
The kill or be killed order is...
I say aside from that kill or be killed, if you don't succeed on that, is there another incident that comes within the statutory definition?
I don't think any of the other incidents by themselves would constitute torture. I do not believe that.
Thank you.
You're abandoning the claim based on the beating?
I think the beating gives good context for how he and his family were treated since 1979. It's relevant for that. It's certainly relevant for damages.
But it's not enough by itself.
I don't think it's enough by itself, and it's debatable whether some of that's by Iranian officials specifically. Admittedly.
Okay. Yeah.
All right. Why don't we hear from appointed amicus?
Thank you, Your Honor. Erica Hashimoto from the Georgetown Law Center. And with the court's permission, a third-year law student, Diala Al-Qadi, will be representing amicus.
Thank you very much. We appreciate your assistance to the court. Yes, amicus?
Your Honor, and may it please the court. Mr. Radmanesh has lived through unspeakable circumstances during his time in Iran. Circumstances that no...
Sorry, can you speak up? I'm not hearing you very well.
Mr. Radmanesh has lived through unspeakable circumstances during his time in Iran. Circumstances that no individual, let alone a teenager, should endure. But even taken as true, those circumstances do not meet the limited exceptions that Congress has set out in bringing suits against foreign states. The Supreme Court reiterated just 2 days ago, the terms torture and hostage-taking have been defined explicitly and with precision. And Mr. Radmanesh has not met his burden that Iran's conduct fits either definition. Mr. Radmanesh was required to establish 3 elements with respect to torture: custody, severity, and purpose. His allegations that he was tortured before he was conscripted fail because he cites no authority to suggest that the monitoring or prohibition on international travel meet the custody prong within the meaning of torture. As to severity, this court has repeatedly made clear that suffering alone is insufficient. The acts must be extreme, deliberate, unusually cruel, and not the unforeseen or unavoidable incident of some legitimate end.
So can I ask you about the beating? Is there any, can you imagine any circumstance in which the government sends out a group of thugs to beat someone up? They don't take him into traditional custody. They just go beat him up. And they don't use any torture implements. They just punch him and kick him. Is there any beating on those set of facts that would constitute torture? So suppose they just beat him completely senseless. Wouldn't that be torture?
No, Your Honor, because this court in Price has held that not all police brutality and not every instance of excessive force will meet the definition of torture. But in addition, it has to be done for a purpose that's delineated in the statute.
Well, let's just talk about severity for a minute. So we said in Price that sustained and systematic beatings can count. And we also said that the key determinant is the degree of pain that's inflicted. Absolutely. So I would think particularly the latter point would imply that you could have a one-time beating that is severe enough to amount to torture.
Your Honor, this court in Simpson 1 remanded to the district court where the plaintiff was beaten, interrogated, and threatened with death, finding that was insufficient to meet the severity requirement of torture. So in the hypothetical that you suggest, that wouldn't still not meet the severity requirement. In fact, in most cases that the district court has looked at with respect to severity, it has found a pattern of abuse, including being kept in stress positions, hung from the ceiling, repeatedly denied medical treatment. And so even in that hypothetical, we don't believe that would meet the severity requirement that the torture section requires. Mr. Radmanesh also fails to establish that Iran acted with one of the purposes that the torture definition contemplates. Similarly, Iran did not take Mr. Radmanesh hostage because he was not held captive for the purpose of enticing any third-party action. As this court in Price held, detention for the purpose of moral symbolism is not hostage-taking. Mr. Radmanesh's experiences are awful and harrowing. But the reason that the Foreign Sovereign Immunities Act exists is to ensure that unless the acts rise to the level of universal condemnation, they will not bring foreign governments within the jurisdiction of U.S. courts. And if the court has no further questions, this court should affirm.
Any further questions?
No further.
All right, thank you, counsel. Amicus? All right, so, counsel for appellant?
Thank you, Your Honor. As to the severity element, it can be tempting to look at the cases just against Iran. They're well noted and documented throughout numerous courts. The Azada case, Scipio, Frankel, Kilburn, Maradi, cases involving kidnapping, murder, genital electrocution, solitary confinement with no purpose at all, not tied to a rational imprisonment. It can be easy to look at the extremely high bar that Iran has set for severity and torture, including of Americans, and say, well, this one's not quite as bad as the others. And the problem is it rewards Iran for setting their own bar so high for torturing Americans who happen to be in their country or not even in their country when it's Hamas or others that kidnap them. And they've set the bar so high that to fall short of that is something less than torture. The kill or be killed order is as severe of psychological and mental torture as you can have. It is far beyond Russian roulette. It's not play a game and you may get killed. It is kill or be killed. It is forcing someone who is unwilling to do so to go murder somebody. If that order had been to the Iranian soldiers in general, it undoubtedly would not satisfy torture because it wouldn't satisfy the intent element. But the kill or be killed order at gunpoint by itself is not only severe, but it also satisfies the intent. What that is worth and whether that it prolongs harm in such a way that it is worth X dollar amount is a damages question, which remains to be determined by the district court. I'd ask that the court reverse and render default judgment.
Thank you. We will take the case under advisement.
Case number 20-1235, Stephen C. Finberg, Petitioner, versus United States Department of Agriculture and United States of America. Mr. Diaz for the petitioner, Mr. Spicknell for the respondent.
Good morning, counsel.
Morning, Your Honors. Lou Diaz appearing on behalf of the petitioner, Stephen C. Finberg. May it please the court. Petitioner requests the court to reverse USDA's decision finding Mr. Finberg responsibly connected to Adams Produce because petitioner was not actively involved in the activities resulting in the violation and because USDA has determined that Adams Produce was the alter ego of Scott Grinstead, the CEO and owner of Adams Produce at the time of the violations. PACA's responsibly connected provision affords owners, officers, and directors of a PACA violator to avoid the harsh employment restrictions imposed by the statute if they can satisfy a two-pronged test. The first prong is they must show that they were not actively involved in the activities resulting in the specific violation. The second prong requires them to either show that they were a nominal officer and director or they were not the owner of the PACA violator, and the PACA violator was the alter ego of somebody else. In this case, the violation in question was the failure to pay $1.9 million to produce suppliers of Adams.
Which happened because the company spiraled downward and went into bankruptcy and couldn't pay suppliers, right?
Yes, Your Honor. Actually,
and that happened because the bank pulled a letter of credit because there were reports of mismanagement and an investigation of fraud on the Department of Defense, correct?
No, there is no evidence that why the bank swept the funds. The ALJ and the judicial officer concluded that there were four main factors that caused the downfall of Adams. The first one being Mr. Grinstead's falsification of financial records to get a capital infusion from CIC in the amount of $7.5 million. The second was Mr. Grinstead's embezzlement, theft, and fraud to enrich himself personally in the amount of $400,000. The third was the negligence of the auditing company to uncover Mr. Grinstead's fraud of the financial records. And then the fourth was the sweeping of the bank account by PNC Bank of monies that were specifically earmarked to pay the PACA Trust creditors. There's no evidence that Mr. Finberg was involved in any of those four activities.
But there's testimony that one of the reasons people started to lose faith in this company was a DOJ investigation of a DOD fraud.
There is no evidence, Your Honor, that indicates that the DOJ fraud or the failure to disclose the DOD fraud was the result of the downfall of Adams. There is absolutely no evidence. In fact, the DOD fraud was the subject of a whistleblower complaint approximately 1 year before Mr. Finberg became aware of the DOD fraud. Mr. Finberg was not charged with being complicit with the DOD fraud. He was only charged with misprision of felony for failure to report the DOD fraud to the federal authorities. When he learned of the fraud, he went to his superior, Mr. Grinstead, and told him about what was going on. His failure was not to report it to the federal authorities. Here we have a violation, which is failure to pay produce suppliers. In this case, there is no nexus. The department has not provided any substantial evidence to show that there was a nexus or any direct causal link between the failure to report the DOD fraud and the failure to pay produce suppliers. The judicial officer basically just said, you know, the misprision of felony was basically just the general downfall of Adams, or because Mr. Finberg didn't report it, it allowed the DOD.
I take your point that there are other causes here. There were other frauds in which Finberg was not involved, and maybe they're sufficiently distinct that you think of them as different activities. But the DOD, there was testimony that the DOD fraud was one significant piece of the company's downfall.
Well, there's testimony that there was negative publicity, but that was offset by other testimony that said that Adams was functioning and functioning well before the sweep of the account.
If the evidence is conflicting, then there's substantial evidence to support the determination.
There is absolutely no substantial evidence to show that the failure to report the fraud caused the downfall of, caused the failure to pay the produce suppliers. In this case, you have, the department could have.
In terms of his involvement, you have what he pleaded guilty to, which is undisputed. Also in the record is the indictment, which says that he was actively involved in concocting the fraud from the outset. Can we consider that? And if we can consider that, he's not just a passive observer. He is actively involved in a fraud that results in the downfall of the company.
Your Honor, there was testimony by Mr. Finberg in which he specifically pled guilty to misprision of felony. He did not plead guilty to being complicit in the felony that was going on. All he pled guilty to was failure to report the actual violation.
But the indictment is evidence in this administrative record. It charges him with more than that, and it's his burden in this proceeding. It's his burden to disprove his involvement.
But the facts of the indictment were never proved in a court of law. It's merely just an indictment. It can't be used against Mr. Finberg because there was no trial to prove that the facts of the indictment were true. He merely pled guilty to failing to report the fraud to the Department of Justice. Again, you have to look at all the facts here in this circumstance. The USDA, in the companion CIC director's case, found Mr. Grinstead was the alter ego of Adams. He was the bad actor. But USDA says, Mr. Finberg, I'm sorry, you're not entitled to use that finding or the alter ego defense because you, unlike the CIC directors, didn't put personal money into the business. You didn't help root out the wrongdoing, and you're not an innocent party. However, the standard doesn't require an examination of the petitioner's conduct. It doesn't require him to put money into the corporation to assert the alter ego defense. In this case, Grinstead was the alter ego of Adams. He was found to be the alter ego of Adams, and therefore, Mr. Finberg has satisfied both of these problems. I will reserve the rest of my time for rebuttal.
All right, thank you, counsel. Counsel for respondent?
As may it please the court, my name is Charles Spicknell. I'm here on behalf of the U.S. Department of Agriculture in the United States. I'll start with my opponent's arguments about active involvement. He says there's no evidence linking the criminal activities that Petitioner Finberg participated in, which specifically was a fraud against the United States, to the downfall of Adams and the resulting prompt payment violations of the PACA. That's wrong. There is. I mean, first of all, the government did not start investigating Adams because of any of these other activities, because Grinstead was putting personal expenses on his credit card, or because he made the outside investment firm pay too much for Adams.
Get to the point on that, the question of causation, whether he is responsible for or was a part of the causation of the acts for which the proceeding is held.
Sorry, Your Honor. Yes, the two directors who were on the special committee that was formed to respond to the fraud were the first to testify at the administrative hearing. They said the fraud against the government and the government's investigation was significant for four reasons. First, the company hired Fulbright and Jaworski to represent them. They incurred millions of dollars in legal expenses. Second, Adams lost business, not only as government. Oh, I'm sorry.
Just on that point, I thought the outside directors paid
that,
not Adams.
Well, they were very specific. They did say that at the hearing, but they cleared that up. Mr. Johnson did. He was one of the directors. Technically, those expenses by the company, and they invested in Adams an additional $2 million to help pay those costs and the legal fees, and to see that some of the PACA.
So how does that then become a cause of this non-payment for which this proceeding is brought?
Well, I mean, the company incurred the funds. The fact that the outside parties wanted to save the company and put funds into the company.
How did the activities of Mr. Finberg cause the non-payment?
Well, with regard to the investment that we're talking about now, at the end of the day, the company went bankrupt. The money they put in wasn't enough to satisfy, the company's obligations. It went bankrupt, and it left $1.9 million in produce debts unpaid, which is a violation of the PACA.
The problem is you have a lot of bad things swirling around here. You have at least three different fraudulent schemes. You have a somewhat attenuated theory of causation because the PACA violation has nothing to do with the fraud on DOD, right? So he's involved in defrauding DOD, which in the short term is going to make the company more able to pay its other debts because they're having more money come in than they otherwise should. And then things go bad, and we're trying to figure out, is it Grinstead? Is it one of Grinstead's frauds? Is it another? What's going on here? You have a pretty short time frame between when we know DOJ to be investigating and when the company fails, and just nothing in the administrative orders analyzing the causation question. It's just pure ipsa dixit.
I mean, I think the problem is, I'm not sure that this was front and center when the JO wrote her opinion. And I think there is substantial evidence. I don't think that it's, I think there is ample evidence now that the issue has been raised. I don't think you can say the judicial officer missed something in the record that makes her opinion arbitrary and capricious. And that's because not only did they incur legal expenses, they lost business, but they also lost outside investment, so they couldn't get enough money to save it, and they also lost the bank financing.
You think it's enough to meet the causation requirement of this proceeding that he closed his eyes to something else that cost the company money? Isn't that an awfully broad interpretation, counsel?
I don't think so. It's clearly one of the activities that brought down the company that left the produce payers unpaid. As Judge Katsas says, there was three of them. There were personal expenses, there was inflating the profits of the company, and there was this. And
anything that shows they would have paid this stuff for which they had a non-payment if it hadn't been for what he did.
I'm sorry, I missed your question.
It's a but-for question. Is there anything in the record that shows the company would have paid these bills for which they had made a non-payment had he not done what he did in covering up the other fraud?
Well, I think there is. The directors very clearly testified that at some point they discovered what the government was investigating, and they went to the bank, PNC Bank, their lender, and they said, look, here's what we know. Employees and officers within the company have been defrauding the government, and we also had this internal fraud where Grinstead was inflating the receivables. So they told the bank about both, and that was the pivotal event because the bank...
Well, for this proceeding, though, is not about either one of those, is it? It's about the non-payment, right?
That's right, but, you know...
and I'm not hearing you answer my question as to what is it in the record that says they would have paid, they would not have incurred this non-payment but for something that Mr. Finberg did.
Well, I mean, I think it is linked because when they told the bank about the fraud, the bank withdrew the company's line of credit, and the director said very clearly that was it. We were dead in the water. Without new investment, without a line of credit, we couldn't operate. Therefore, the company couldn't pay the backup suppliers.
So I guess the bottom line question in one sense is, was the judicial officer's opinion sufficiently specific on causation?
Well, I don't think that's the issue. I think, you know, even if it wasn't...
I think that the but-for question implies that there were lots of things going on, that some findings that were made in the related proceeding being contrary to the implication of the decision here. But as your brief points out, there's all this other evidence, but that's not what the joint judicial officers cited or even referred to.
Right, but the judicial officer was affirming the ALJ, the administrative law judge's decision, and she affirmed his findings of facts and cited back to that decision.
The ALJ decision was equally perfunctory on this point.
Yeah.
That doesn't get you anywhere.
All right. I mean, I think there's substantial evidence to show that this was one of the causes, one of the activities.
I have to ask you also about the alter ego question. How could the miscreant be an alter ego with the company in proceedings with the three other people, but not be an alter ego in this one? Either he was an alter ego or he wasn't an alter ego, or the company was an alter ego, wasn't an alter ego, wouldn't it? How does it come out with two different answers to that question?
Well, I think that, you know, the standard for alter ego is Quinn, and we also cite Vegmix.
Give me the standard.
Okay, the standard is not only do you have to have a dominant owner, which Grinstead was found to be in the prior proceeding, but you also have to show an injustice. And he can't show that injustice because he participated.
Isn't that two different questions?
It is two different questions, but that's clearly part of the test in Quinn, and Vegmix makes that very clear, this court's decision in Vegmix, which we cite in our brief, as does the Eighth Circuit's decision in Tupelo, although clearly that's not binding. So it's not just, you know, whether there's a potential, you know, dominant owner. It's whether there's an injustice because, you know, we're essentially setting the corporate form aside to let someone who's really an officer go because, you know, we're going to ignore the fact they're an officer because it's an injustice that we're trying to prevent. And in this case, there is no injustice. He was a participant in the fraud against the government, which clearly had significant financial consequences for the company and ultimately for its suppliers.
So since the statute has a presumption that places the burden of rebutting it to the Mr. Finberg here, does that reduce the obligation of the agency to demonstrate a but-for causation?
Yes, I think that's true. I think in this case, for example, he said, we don't know exactly why PNC Bank withdrew the line of credit and swept the accounts. Well, it was after the company reported both frauds to them. He could have called someone. It was his burden if he wanted to say, PNC withdrew the line of credit. The decision had nothing to do with the fraud against the government. He could have called PNC Bank. He also had a right to cross-examine the directors at the hearing. So when they said all this, he could have, if he wanted to winnow out this point, that there was no connection between the fraud he participated in and ultimately the company's collapse, he had ample time to cross-examine the witnesses. I'm sorry, Your Honors, I see I'm out of time. I'd be happy to continue.
So,
sorry, go ahead.
If the agency itself in its decision has not demonstrated a but-for beyond the presumption in the statute, it doesn't matter?
Right, it's his. I'm sorry to cut you off.
I'm trying to understand. It's like the prosecutor issues an indictment, but when put to its burden of proof, can't prove it. And the defendant can't be convicted. And I understand there's no burden there, but I'm just trying to understand how this statute works. Is it enough to say, look, Adams couldn't pay its suppliers, and anybody who's an official in the company who can't prove the two elements is necessarily implicated?
Yes, that is our position. That is what the statute says.
Even taking that position, hasn't the evidence demonstrated that there was not any direct connection between his actions and the particular default for which this proceeding was brought? I mean, that's the only way you can prove a negative, is that you establish the weakness of the evidence for the positive. He's not going to have something ever that's going to be direct evidence of a negative. So why isn't this, in this case, a failure of that element?
Well, I don't think he has to have direct evidence of a negative. I think when the directors testified that they reported this fraud and the internal fraud to the bank, and the bank pulled the line of credit, which put the company dead in the water, I think he needed to ask, are you sure? Have someone...
You don't leave much meaning in this statute if it's sufficient to show that he did something else that cost the company to lose business or lose status or lose credit. If that's sufficient, then you don't really need that element of this statute. You're not putting much content in this, are you, counsel?
Well, I mean, I think in a lot of cases, this case is different. In many cases, we have an officer who, for example, looted the company as it's going down. That was Norensburg, the case we cite for the standard of active involvement. Prior to the company's collapse, the family wrote checks to themselves and took money out that could have been used for the produce. Again, it's not, and that's what we went after them for. Again, it wasn't that they themselves didn't pay the produce sellers. It was the reason the company didn't have the money to pay. And in this case, the reason the company couldn't fulfill its obligations under PACA was because of the various fraudulent schemes perpetrated by employees and officers within the company.
All he pleaded guilty to was misprision. Is there anything that shows that had this fraud been disclosed at the moment he learned of it, there would have been any difference in this non-payment situation?
Well, I think, this fraud, fraud by its nature is a secret. We're speculating either way because that's not what happened, but to really, had he disclosed the secret to the government, it's reasonable to assume that it would have stopped.
No, we're not talking about assumptions. We're talking about, you say it's reasonable to assume it would have stopped. If it had stopped at that point, is there still any evidence that this payment would have been made?
I think potentially, certainly we wouldn't be here for this responsibly connected proceeding if he hadn't concealed the fraud, which is what he admitted to in his plea, and agreed to continue it, which is what the facts he admitted to in his plea agreement.
Are we allowed to consider the allegation that he didn't simply conceal the fraud, but he was actively involved in creating it? That's the allegation in the indictment. He didn't plead to it, and a friend on the other side has at least an intuitively appealing point that that's just an allegation that hasn't been tested.
Right, and that is his argument, and we didn't make much of the indictment in the brief. He does testify.
Is there evidence, though, outside the indictment? Is there evidence of that in this record?
No, there is not.
Thank you.
Unless there are any further questions.
I have one other question. You suggested, I think, that causation was not the focus before the ALJ. And now I think you said that the issue has been raised. Are you suggesting that the causation issue was not raised until the appeal to this court?
Yes, that is what I'm suggesting. I don't think it was squarely raised to the ALJ, and I think, I'm not sure it's
squarely raised. Let me say squarely raised. If you strike that adverb, right.
I have read. I'm sorry, Your Honor. Yes, I reviewed the briefs below, and it's my opinion that it was not raised, and that's why the opinion that she wrote reads the way it does. And I would say, I guess, we didn't raise that issue, and I didn't chase it down because it would be arbitrary and capricious if the judicial officer missed, a chunk of evidence in the record. But he has no evidence that the fraud he participated in was not one of the factors that resulted in the bankruptcy of the company and the failures to pay.
Well, I thought that was an implicit causation argument. Maybe I'm wrong.
The causation.
You have proved the connection of my action to the specific charge brought against the company.
Yes, the judicial officer has defined what activities resulted in the violations of the PACA. And in this case, the administrative law judge found there were three: the misuse of company funds, the fraud against the government, and the fraud against the company itself. Of course, he participated in only one of those. So the fraud against the government was one of the activities that resulted in the violations of PACA.
On the preservation question before the agency, the causation question was raised in this court in the blue brief.
Yes.
And unless I missed it, you didn't argue forfeiture in your red brief. And so forfeiture arguments are themselves subject to forfeiture, so haven't you forfeited that objection?
Yes, Judge Katsas, that would be correct.
All right, anything further?
Nothing further. We would, no, nothing further from me. Thank you, Your Honor.
Thank you, counsel. All right, counsel for petitioner.
Your Honors, I have nothing further to add. I would just like to point out, again, if the Department of Agriculture wanted to charge Adams with fraud or fraud on the DOD, or as Judge Sentelle dealt with a case where they charged a breach of an implied duty with respect to a produce transaction, they could have, but they didn't. It's solely limited to the failure to pay produce suppliers, and there's no causal connection between failure to report the DOD fraud and the failure to pay.
Can I just ask one question? Suppose we think there's no connection. There's no adequately shown connection between his individual acts or omissions and the failure to pay. Don't you still have a little bit of a problem, because the statute doesn't require causation between the individual's misconduct and the violation? It requires that he be actively involved in activities that cause the violation. So isn't it enough, even if we can't trace what Finberg did to the failure to pay, isn't it enough if the record has substantial evidence that he was involved in the one fraudulent scheme, and that scheme was a substantial factor of the company's not being able to pay?
I think it's different, though, because the way that was couched was you indicated that he was involved in the scheme.
Actively involved.
No, but you said he was actively involved in the fraud. All he was found guilty of and pled guilty to was failure to disclose the fraud. There's no evidence that he was a participant in the fraud. So we have to show, hey, if he reported this, would this have prevented the violation from occurring? And this court in Nuremberg specifically was pretty clear that the legislative history for the amendments in 1995 to the actively involved standard was that Congress wanted to make it clear that Congress wanted to amend the definition of responsibly connected to provide that individuals were given the opportunity, and I'll quote, to demonstrate they were not responsible for the specific violation. In this case, Mr. Finberg is not responsible for the failure to pay Adams produce suppliers.
That statute reads a little bit more broadly than that. I mean, I guess you could say that concealment as a matter of law can't constitute active involvement, but I'm not sure that's right. I can conjure up a hypothetical where the concealment would be absolutely critical.
Okay.
Thank you, Your Honors.
Thank you. We'll take the case under advisement.
This honorable court is now adjourned until Thursday, February 11th at 9:30 a.m.
You have been added to the waiting room. You cannot talk or listen until the host admits you to the meeting. System error. Error code 109.